What does it mean to be retaliated against at work in California? People complain about things all the time at work, and sometimes their employer punishes them for those complaints. But that doesn't necessarily mean that the law was violated. So what's the legal definition of retaliation? And since the majority of people who watch this video will probably be employees, if you complained about something and your boss retaliated against you, what legal protections are available to you? If you were fired, what legal remedies do you have? Should you even contact a lawyer? We're going to unpack and answer all of those questions in this video. It's usually not that blatant, but people get retaliated against all the time in California. So let's take a look at the law. California's retaliation law is not just one law, it's a bunch of different laws. And in this video, I'm going to cover all the main ones. First and foremost, California Fair Employment and Housing Act, found in the Governmental Code, section 12940, subsection H, is all about when an employee complains about unlawful discrimination or harassment and is then retaliated against for that complaint. California Labor Code section 1102.5 is all about when an employee refuses to do something that's unlawful and is then retaliated against for that. The Fair Labor Standards Act, FLSA, is all about when an employee complains about their wages not being paid properly, not being paid on time, filing a wage complaint with the labor board, and then being punished for the complaint. California Health and Safety Code 1278.5 is all about when an employee in a hospital environment complains about an unsafe patient care or condition and is then punished for the complaint. And last but not least, California Labor Code section 6310 is all about safe working environments. If an employee complains about an unsafe working environment and is then retaliated against, they can bring a retaliation claim under that law. Let's dive in a little bit deeper. The California Fair Employment and Housing Act 12940 subsection H says that it is an unlawful employment practice for an employer to terminate an employee because that employee opposed unlawful discrimination or harassment. Now, what in the heck does that mean? Let me give you an example. Let's say you're 64 years old and people tease you at the office for being the old guy. Well, let's say you go complain to HR that you don't like being teased because of your age, and then they fire you because of your complaint. Well, that would be a violation of this law, and you could bring a retaliation claim. But you might be asking yourself, why did I underline unlawful? Isn't all bullying at work unlawful? The answer is no. The only time discrimination or harassment are unlawful under California law is if they are done because of protected categories set up in the law, such as age, race, religion, sexual orientation, disability, ethnicity, so on and so forth. If you want to learn more about the protected characteristics, go to the discrimination page. Next, let's talk about 1102.5. Remember, this one is all about an employee refusing to violate the law. Let me give you an example. Let's say you work at a restaurant and you find out that the head chef wants to serve 6-month-old moldy food to the customers. And you go to him and you say, this is totally unacceptable. This is breaking the law. I don't want to have anything to do with this. Well, if he fires you, you can bring a claim under this law. Similarly, let's say as opposed to confronting your boss, you go to the Department of Health and you say, hey, he's serving 6-month-old moldy food to the customers. This is crazy. And if your boss finds out and then he fires you, again, you also can have a claim under this law. Next is the Fair Labor Standards Act. This law is all about money. It's all about overtime, minimum wage, getting paid properly. The Fair Labor Standards Act set up a rule that says if an employee complains about not getting paid properly and they file a wage complaint with the labor board, and then they're retaliated against, that's against the law. But what's even more powerful about this statute is if you complain to the employer that you're not getting paid properly and the employer then retaliates against you, again, you have a claim under 29 U.S.C. 215, subsection A, subsection 3. One of the most powerful retaliation laws in California is actually better known as a whistleblower law. It's Health and Safety Code 1278.5. Remember, this law is all about patient safety. If you work in a healthcare organization and you are a doctor or a nurse or any type of other medical professional and you witness something that you believe to be unsafe for patients, whether it be unsafe care at the hands of another provider or unsafe conditions, just the hospital's not up to par, and you complain about it, and if you're retaliated against because of that complaint, you have a claim under this law. Last but certainly not least is Labor Code Section 6310. Remember, this law is all about safe working environments. So if you view something and you think it is unsafe for either yourself as an employee or other employees, and you complain about an unsafe workplace, whether you complain to OSHA or you complain to the employer itself. So say you go to HR with a safety complaint and then they fire you or they retaliate against you in any way, you can bring a claim under this law. If you lost your job in retaliation for making one of these complaints, would it even be worth it to file a lawsuit? Should you contact a lawyer? What kind of remedies are available to you? Let's first look at the remedies. In the majority of these cases, you can get the following types of damages. The first and very important are your economic damages. These are the lost wages as a result of being fired. So let's say you're making $75,000 a year, you get fired, you're not making $75,000 a year anymore. So it's a very tangible economic loss that the jury can measure. Second, emotional distress damages. These are extremely important and are often the largest component of retaliation cases. These are the damages you get for the mental pain and suffering that you go through because of the really bad behavior. These are very real, especially in severe cases. Third, punitive damages. Everybody's heard about punitive damages. These are the damages meant to punish the defendant, but they're very difficult to win. You have to prove that they fired you with malice, oppression, or fraud, which is a higher burden, and it's very difficult to do, but in severe cases, this can be by far the largest component of the case. Fourth, in some cases, you can also get your attorney fees, especially in FEHA cases. And this is very powerful because sometimes this is larger than the rest of the damages combined. And that is a big incentive for the employer to settle early on so they don't incur too much in attorney fee liability. So is it worth it to bring one of these cases? Well, the answer is it depends. Every case is different. Everybody's got different economics, different emotional distress. Some employers behave worse than others, yet there's still liability. So the answer is we can't really give you yes, you should file the case, or no. We can't really say what the average retaliation case is because retaliation case settlements are confidential. We don't have averages. But at the end of the day, I can say this. If you bring a retaliation case and you win, you're going to be happy. Not even because of the money, but because you will have taught that employer a very significant lesson that is absolutely unacceptable to terminate somebody for doing the right thing.